This is the video lecture for Chapter 8, which begins our study of contract law. We are going to do a brief overview of contract law, and then we're going to dive into two of the four required elements for a valid contract, those being an agreement and consideration. So generally, as an overview of contract law, there are two main sources of contract law. One is the common law, and so those again would be cases that have developed over time, court decisions that specify when a contract is legally binding on a person or a party and is enforceable. In some instances, states and to a much lesser extent, Congress have enacted statutes that govern contract law. And the most prevalent of those is something called the Uniform Commercial Code, or the UCC for short. The UCC covers the sale of goods in the business setting, and we're going to get into that more in depth at a later part of the course. But do know that the UCC is, as it sounds, it's a uniform set of laws that's been adopted by each of the 50 states so that the sale of goods and the law that governs contracts for the sale of goods is uniform across the country. And we will again get into that later. So the main sources of contract law, you'll see a lot of common law. In fact, the first two cases that you're assigned to read for this week involve court decisions about whether a contract is enforceable or not. And then, of course, statutory law, primarily the UCC. The function of contracts is to provide stability and predictability in society, more specifically business, and that the fact that we can rely on the promises that are made, that helps form the basis of our market economy. It could not operate without contract law. In fact, much of society could not operate without contract law. Definition of a contract, the one we're going to use in this class, is that a contract exists if it is enforceable in a court of law. So if a contract creates a legal right in one or both of the parties such that they could enforce that in a court of law, then there is a valid or enforceable contract. We use valid and enforceable as equivalent terms in this chapter. Can you enforce it in court? That determines whether or not you have a contract. The objective theory of contracts we'll mention a couple times throughout this chapter. And what that means is, to the extent that courts and people who are parties to contract have to decide whether or not the other party had the requisite intent to enter into a contract, we're not required to read the other person's mind. We are allowed to go on any objective evidence, manifestation that the other person exhibit, their writings, their words, their actions. And again, that provides much more predictability and stability to the area of contract law, because if we had to go around determining what somebody's subjective intent was, we'd go around that tree forever, and courts would have a lot of difficulty in deciding which, if any, contracts were ever enforceable. So we do look at the objective theory of contracts. One example of that is one of your assigned cases, the Lucy versus Tzemre case. Studies how a court applies the objective theory of contracts to whether these two guys who had been drinking at a bar had actually entered into an enforceable contract for the sale of land. One party thought they did. One party later on claimed that he was just joking and was never serious. And so you'll see how the court treats those two arguments in its opinion. Hold on. No. Don't chew that. No. The bad dog is here in the office with me, and she's mad because we're not going home until I finish this contract, so I apologize for that. We were at requirements for a valid contract. So this is important. The four elements for a valid contract, an enforceable contract, are an agreement. Agreement is going to be broken down into an offer and an acceptance, and you'll see that in a minute. We'll get into that in depth. The second element is consideration. In other words, something of value has to be exchanged, promised, or given up by both sides. the people who are entering into the contract have to have capacity to contract. So someone who is obviously intoxicated or is mentally incompetent, has Alzheimer's, those things can negate the element of contractual capacity. A minor is someone who doesn't have the capacity to enter into a contract. So those are examples of things that might negate that third element. So we've got agreement, consideration, contractual capacity, and then the last one is legality. A contract has to be for a legal purpose. If I hire a hitman to kill Carol Baskin, that is not an enforceable contract because it has an illegal purpose. So legality is the fourth element. You're going to see that because contracts are generally an area of the common law, there are a lot of exceptions to the general rule, and it can make it a little bit difficult. But the goal of this class, just like in other chapters, is not for you to memorize the minutia of every possible scenario of contract law and each discrete objection or defense, but to get the general idea of what it takes to form a contract, what some of the defenses are, and some of the other general ideas that surround contracts. Yeah, I'm really sorry. No chew in the chair. Y'all want to see the bad dog? Come here, say hello. All right, here she comes. Tell them how bad you are. You're a bad dog? Yep. All right. No chew in the chair or furniture or the wall. You got it? All right. Some other defenses to the enforceability of a contract might be that if consent agreement is not voluntary because of either duress or undue influence or pressure, then that would negate a contract. Or sometimes a contract has to be in a specific form. And if the contract is not in that specific form, then the contract won't be enforceable. And we'll get into what those types of contracts are in just a minute. Some general categories of contracts, again, these are more informational, kind of give you a little bit more insight into the different types of contracts, but not anything that is going to be earth-shattering or really necessary for you to memorize past this course. But certain types of contracts are described by how they're formed. So the first distinction is a bilateral contract versus a unilateral contract. A bilateral contract comes into being when one party makes a promise to the other and the other party makes a promise back. An example of that would be, I will pay you $5,000 if you'll drive my car from Georgia to California. And if the other party says, yes, I accept that offer, I will drive your car from Georgia to California, then we have a bilateral contract. I've promised to pay the $5,000. The other person has promised to drive the car. Unilateral contracts, however, are a little bit different. That is where one party makes a promise and the other party doesn't make a promise in return. The other party completes the action or the obligation that is implied. So if I said to you, instead of, will you drive my car from Georgia to California for $5,000, I say, if you drive my car from Georgia to California I'll give you $5,000. So I've made a unilateral contract that only becomes binding once you have accepted that offer, and you would accept it by actually performing the drive to California. A subtle difference, most contracts are going to be bilateral. In my example, if I needed my car driven from Georgia to California, I really wouldn't want to throw that out there and then wait to see if somebody, takes me up on it. So most contracts, again, are going to be bilateral, but unilateral contracts do exist. Once a person begins to perform the unilateral contract, then that offer becomes irrevocable. So if I said to you, if you drive my car from Georgia to California, I'll pay you $5,000. If I revoke my offer before you have undertaken the drive, then I can do that. But if you're halfway across the country in Kansas and I call you up and say I've changed my mind, I revoke my offer, then I can't revoke it at that point. So an important distinction can be made there. Formal versus informal contracts. Formal contracts require a special form of communication and acceptance to be enforceable. We'll look at some of those later, like some that are required to be in writing, but another example for that is a check has to be in a special form. We can't handwrite a check, make up our own check. A promissory note, a certificate of deposit, those things have to be in a certain form in order to be enforceable. Express versus implied contracts. The distinction here is whether or not the promises were made either in writing or verbally, or whether the obligation or the contract was created by conduct of the parties. So, for example, I go and see an accountant to interview that accountant to see if I want her to prepare my taxes. We discuss what all is involved. I ask her what her price is. She tells me what her price is. Then I go home and say, okay, I'll think about it. The next day, I gather all my materials. I drop them off at her office. And so even though I have not said, I accept your offer, we don't have anything in writing, my conduct can be interpreted as accepting her offer to do my taxes for the amount that she stated. There's a really good summary on Exhibit 8.1, page 210, that kind of summarizes a good little chart of how contracts are formed. No chew in the chair. No ma'am. Contracts can also be distinguished in terms of whether they've been performed or not. If both sides' obligations have been performed, then that is considered to be an executed contract. If one party has performed but the other hasn't, or if neither party has performed, then that is considered to be an executory contract. All right, what makes a contract valid or enforceable in a court of law? We have to have, again, all four of our elements. Offer and acceptance, which would constitute agreement. Consideration, the persons making the contract have to have capacity, and then it has to have a legal purpose. A voidable contract is a contract that has all of those elements, but it reserves the right in one party to get out of the contract. An example of that is a minor who buys a car. The law of Georgia and most states is that a minor does not have capacity to enter into a contract to buy a car before the age of 18. So if my 17-year-old son goes and buys a car, then that contract is voidable by him. He could go and turn the car in and say, I void the contract because I didn't have capacity at the time. There are unenforceable contracts. Those are contracts that have all of the required elements, but for some reason they're not enforceable in court because one party has a good defense to the contract. An example of that would be that, as you'll find out later, any contract for the sale of land has to be in writing to be enforceable. So let's suppose that you and I make an oral agreement to buy a piece of land, and we've agreed on consideration. Everybody has capacity. It's legal. We have an offer and acceptance, but we don't have it in writing. So that is an unenforceable contract. Even though we've met all of the elements, it is not in writing as the law requires. So that is an example of that there. A void contract is a contract that was never enforceable from the get-go. My contract to hire the hitman to kill Carol Baskin, there is no contract there because it was not legal. So it's not voidable or unenforceable. It's just void. Void and contract are completely contradictory terms. So we can't have a void contract. We can't have a contract and have some elements of it be void at the same time. There is a thing in the law called a quasi-contract. And this is a situation where the elements of the contract are not all met, but the law is going to impose a contract on the parties, because if they don't do that, then it would result in one party being unjustly enriched by the other party. So these are treated as if Quasi-contracts means as-if contracts. So they're treated as if there was a contract. For example, let's say there's a water sewage company that provides water service to a neighborhood development, that has homeowners association they've contracted with the water company. There are also some homes that are outside of the development that also receive services from the water company. And even though there's no contract between the two, if a person who is not bound by the contract and outside that development, if they're still receiving those services and they're paying for the services, then they can't later on claim that they don't have to pay anymore because there was no contract. In that situation, a court is going to say, well, you never objected to it. In fact, you paid for a number of years the water bill. So you can't now claim that you're going to keep receiving the water, but you don't have to pay for it. That would unjustly enrich you at the water company's expense. So even though you didn't have a contract, we're going to impose one on you under the idea of quasi-contract. The first element we're going to look at in contract is agreement. And again, that's broken down into offer and acceptance. It's essential, obviously, to any contract. Again, the objective theory of contracts really applies here, because if we're determining whether someone has made an offer or someone has accepted that offer, we're going to look not at their subjective intent, what their state of mind was, but what their objective actions, words, and writings say about their intent. So requirements of a valid offer. First, we're going to need it to be made with a serious intent by the offeror. So things that are obviously jokes can't be a serious intent. I own a brand new Lamborghini, and I say, hey, I'll sell you that brand new Lamborghini for $10. Ha ha. That's not a valid offer because it's clearly made in jest. An offer has to be reasonably certain and definite, and it has to have terms that can be objectively ascertained. So as you can imagine, if we don't have that, then a court or the other party, if there's a dispute, we're not going to be able to figure out what it is that was actually agreed to. So it needs to be reasonably certain or definite in its terms. It also needs to be communicated to the offeree. Now that might sound pretty obvious and stupid to you, but consider the example of a person who gives a reward for the return of their lost dog. If a person who finds the dog doesn't know about the reward, then there can be no contractual obligation for the offeror to pay the reward because it was never communicated to the offeree or the person who found the pet. That's kind of a mean example, but that is an example. So when we're looking at intent, again, like in so many areas of the law, when we're deciding whether somebody has the objective serious intent, we're going to look at what the reasonable person would think in hearing the words, seeing the actions, or reading the writings. Reasonable person standard on whether the intent was serious. Some things that affect whether or not there was an intent. Expressions of opinion. Those are not offers, especially in the context of salespeople who are engaging in puffery, where they're kind of pumping up the product or fluffing it a little bit. Those are not considered to be offers. For example, an opinion of a doctor, I'm going to do this surgery on your hand and it ought to heal within 2 or 3 weeks. That's not an offer. That does not create a contractual obligation for him to do a surgery that heals your hand in 2 to 3 weeks. That's just an expression of opinion. Statements of future intent are not an offer. If I tell you, I plan to sell my farm sometime next year, and I'm probably going to ask around $1 million for it, and you bring me a check for $1 million the next day and say, I accept your offer, we don't have a contract because I've just made a statement of future intent. I have not communicated an actual offer. Preliminary negotiations are not offers, they are invitations to negotiate. So if I say, for example, would you ever consider selling that farm? That's an invitation to negotiate. I wouldn't sell my farm for less than $3 million. That's not an offer, that's just an invitation to negotiate. Ads, catalogs, circulars, pamphlets, those are generally seen under the law as offers to negotiate. They're not binding contracts. And so, you know, if we took the opposite view and we said, well, an advertisement to sell a phone for $50, that's not a contract, because if we only have one phone and it's sold and then we have 49 more people come in and say, I accept your offer, then we would have broken or breached the contract with those other 49 people. So again, as advertisements, commercials are viewed under the law as invitations to negotiate. Agreements to agree, you know, those used to be not viewed as an actual contract, but the more recent, the more modern view is that if we've entered into an agreement to agree at a future time, and all of the elements exist for a contract and it's definite enough, then many times, and most times, that will be upheld and be enforceable in court. Preliminary agreements, sometimes if they're signed off on and they're definite enough that we can determine exactly what the agreement was, then those can be enforceable. So, for example, you and I sit down and we write on a sheet of paper kind of the bullet points of our agreement, and we're going to come back later and add some of the more legalese language, but we're not changing any of the material terms of our agreement, then that preliminary agreement is most often going to be enforceable. An offer has to be not just serious, but it has to be definite. And we talked about that, and in the parties in the courts need to be able to ascertain what the terms are in the event that there's a dispute over its enforceability. Generally, it will need to identify the parties, the subject matter or the object of the contract. It will need to identify what the consideration is, which we're going to get in next. But consideration is something of value given up by either side. And it generally will specify a time of payment, a method of delivery. Any other material terms like that would typically be included in the definiteness. And then again, it needs to be actually communicated to the offeree in order for the acceptance to create a binding contract. So that goes to the example of the reward for the lost pet that I gave a minute ago. All right, if we make an offer and we throw it out there, how can we terminate that offer? What operates to terminate an offer? One of the ways that it can be terminated is by action of the offeror. So I make you an offer for you to buy my land for $50,000, and I call you up the next day before you've accepted, and I say, you know what, I changed my mind, I withdraw that offer. It's terminated. It could be implied by conduct that is inconsistent with the offer. For example, I tell you, I'm selling my farm for $50,000. I make that offer to you. Just let me know if you want to do it. Well, before you accept the offer from me, I sell it to somebody else. That terminates my offer to you because I've engaged in conduct that implies and that is inconsistent with my offer to you. Revocation is not effective until it's received. So if I make an offer to you to sell you my farm for $50,000, and I text you later on that I've changed my mind and I revoke my offer, but you don't see the text and you call me and accept my offer before you have been communicated my revocation, then that your offer is valid and your acceptance is valid, and we now have a binding contract. So those are the ways that an offeror can terminate an offer. Ways that an offeree could terminate an offer are by rejection of the offer. Offer to sell you my land for $50,000. You say, no thanks. The next day, you cannot call me up and say, I accept your offer to buy your farm for $50,000. Too late, your rejection terminated my offer. Just like revocation is only effective upon receipt, so is rejection. So that would, same thing would apply. If we're just inquiring about an offer, that does not constitute rejection. So if I say to you, I will sell you my farm for $50,000, and the next day you call and say, hey, tell me a little bit more about the farm. What would be included? Would you consider including your barn, or would you consider including the 20-acre lake that is adjacent? Calling the next day or later and saying, hey, is that offer still open? Those are inquiries about the offer, and those would not constitute a rejection. This is important too. One of the main ways an offeree can terminate the offer is by making a counteroffer. So I offer to sell you my farm for $50,000. You say, I will give you $45,000 for it. You have terminated my offer, and you have in turn made a new offer to me. You are now the offeror, and I am now the offeree. This could go on and on. I could say, well, I will take $48,000 for it. I've terminated your offer. I've made a new offer. Now I'm the offeror. You're the offeree, and we keep going around. It could be terminated by operation of law. If the offer specifies that the offer will only be open for a certain period of time and that time expires, then the offer terminates by operation of law. If there is no time period specified, then the offer will be viewed under the law to have been terminated after a reasonable amount of time. Again, whatever's reasonable is always going to depend on what the circumstances are and the facts of each case. Excuse me. Destruction of the subject matter, death, or illegality, those would also terminate an offer. If I offer to sell you my barn for $50,000 and before you accept, my barn burns down, so it's impossible, then my offer is terminated. If the offeror or offeree dies before acceptance, then an offer is automatically terminated. If I make an offer to you for a contract on something that then becomes illegal by a law that's passed after I make the offer, then my offer is terminated by operation of law. Some offers cannot be revoked. If an offeror makes an offer to an offeree and it induces a reliance on the part of the offeree, then they can't revoke. One form of that is an option contract. So if I say I will sell you my farm for $50,000, and for $500, I will give you a 30-day option that you have during which to accept or reject my offer. I can't revoke the offer if you have given me consideration for giving you that option period. All right, so that brings us to acceptance. It has to be voluntary. It could be either by words, writings, or it could also be by contact from the offeree, and that show and demonstrate an objective agreement or assent to the terms of the offer. Except in really limited circumstances, which we don't get into, an offer can only be accepted by the person to whom it is made. There has to be unequivocal acceptance. That means that we can't have some question. It can't be ambiguous as to whether or not there was an acceptance. And generally, we will imply or employ the mirror image rule, which means that the acceptance has to mirror what the offer was. So if I offer to sell you my farm and a barn and the 4 horses on my farm for $50,000, and you say, I accept your offer, but you need to throw in the pond, then we don't have a mirror image. You have not accepted what I've offered. That is, like we talked about a second ago, that is actually a rejection of the offer, and a counteroffer, a new offer, has been made under those circumstances. Silence as acceptance. Generally, silence will not be acceptance unless the parties have a demonstrated pattern of dealing where silence does constitute an acceptance. such as a delivery person texts me at my store every week and says, I'm bringing the usual on Thursday, and if I don't text or write or communicate back to the delivery person that I don't want the usual amount or don't want any amount, then my silence could be viewed as an acceptance if that's the pattern of course of dealing that we have been engaged in over time. Communication of acceptance. Bilateral contracts usually will require some sort of communication of the acceptance because, again, there's a promise for a promise. A unilateral contract might not require the communication of the acceptance. It might just require the performance of the act to constitute an acceptance. And so going back to the driving the car cross-country example, the mode and the timeliness of acceptance does make a difference. So the Mailbox Rule is the rule that's generally applied, and it says that acceptance becomes binding on the offeror once the acceptance is placed in the mailbox, not when it is received by the offeror, and that's a big difference there. If an offer has specific means by which it has to be by which the acceptance has to be communicated, then that would control. So if I make you an offer to sell my land for $50,000 and say that you must accept by email, then any other form of acceptance will not create a valid contract between us. Generally, if the offer does not specify a specific means, then generally any means that is in the same form of communication as the offer or in a faster means of communication than the offer was made is generally going to be accepted. We are skipping in this chapter the e-commerce part of contracts, and we're going to go on to the second element of a valid enforceable contract, which is consideration. Hold on. No chewing that pillow. No, ma'am. Look, she's going to pretend like she's mad at me. Consideration, that is value given in return for a promise. In my cross-country driving example, the consideration for you driving my car is that I'm giving you $5,000. The consideration you're giving me in exchange for the $5,000 is that you're driving my car across the country. There has to be a legally sufficient value to constitute consideration in order to make a contract legally binding. So consideration cannot be a promise that a promise to do something that someone is already bound to do, or something that someone has already done. It cannot be the performance of an action that one is not already obligated to undertake. So if I'm already legally obligated to do something, then that cannot serve as consideration in a new contract with you. The refraining of doing something is consideration, and that's called forbearance. There's a famous example in your book. It's called Hamer versus Sidway. It's not assigned, but I think there's a question in your assignment that pertains to it. And in that case, an uncle promised his nephew a certain sum of money if he didn't, I think it was drink or smoke until he was age 25. The nephew did, in fact, give up drinking and smoking until he was 25. Maybe it was having sex. It was something like that. But anyway, he gave up the doing of something that he had the legal right to do. And the court determined, after there was a dispute over whether or not there was a contract, the court determined that the nephew's forbearance did constitute consideration in that case. There has to be a bargain for exchange, and this distinguishes a contract from a gift. So if I say, I'm going to give you, when I get my bonus, I'm going to give you 10% of it. That is not a contract because you have not given me any consideration in exchange for the promise that I've made to you to give you my bonus. My offer it constitutes a gift. And if I go through with that, that constitutes a gift. There's a general rule that courts are not going to get into whether or not you paid a good price or you received a good price for something. They are generally going to not evaluate the adequacy of consideration and say that folks are free to bargain however they want, and they're not going to substitute their own judgment for the parties who have made a contract. That's true for the vast majority of cases. There are some cases, though, where a court will say, we're going to step in and we're going to say that there was no adequate consideration, there's no bargain for exchange, because a contract is so unconscionable as to shock the conscience. Maybe a contract that somebody, a door-to-door salesman, makes with an elderly person to sell a wheelchair for 50 times the market value. We might say that that's unconscionable, that there was a disparity in bargaining power and in knowledge, and we just don't think that it would be, in keeping with public policy to enforce that contract. So there are times when the court will substitute its own judgment about whether consideration was adequate, but know that most of the time, if you make a bad deal, that's just your fault. Agreements that lack consideration. So when we were talking about legally sufficient value a minute ago, agreements for a party to perform a pre-existing duty, those do not constitute consideration because there's no benefit that's derived to the promisee because the person already had the obligation to do that. There are a couple of exceptions to that. One is unforeseen difficulties. So let's say that I hire a contractor to build my house. Neither of us know that there is an old expired gasoline tank from a service station that is buried there that's going to require remediation and removal. And so when we come back and we do a new contract, or if the contractor says, well, I'll do the remediation work, but you're going to have to pay me another $500,000, and I agree to do that, I can't later go claim, well, he had a pre-existing duty to do that because we already had a contract for him to build my house. So there's been no consideration given to me because he was already bound under the terms of the contract. In the example I gave, there was an unforeseen difficulty, and that could create some new consideration. The parties can always agree to tear up a contract and start over, or they can agree that we're going to negate or rescind our current contract and we're just going to enter into a new one. If that's done, then courts are kind of split. Some courts will look and say, well, you both agreed to tear it up, so you're bound by the new contract, and some courts might look at the pre-existing duty rule to see if there really was anything new that was exchanged as consideration to support the new contract. So not always, mutual rescission will not always result in a new binding contract, so be aware of that. Past consideration cannot be valid consideration. So you gave me a ride to the airport last year. I tell you today I'm going to pay you $50 for that ride you gave me to the airport last year. There is no consideration given because that is a past action that has already happened. Illusory promises are also a category where they will not support the element of consideration. If I tell my staff here at my office that I am going to give everybody a bonus at the end of the year if we do well, and if I think that they deserve it, and if I feel like it at the end of the year, I've not created a binding contract. There's no consideration because it's illusory. There's no way, there's nothing definite about that could be enforced. What does it mean for us to have done well? What does it mean for you to deserve it? What does it mean for me to feel like it? So those are examples of illusory promises. It sounds good, but once you really look into it, it's not truly consideration. How do we settle sometimes when we have disputes about whether there is a contract or whether somebody has not performed their contract? This chapter talks about the doctrine of accord and satisfaction. And what that means is that the parties disagree about what's owed under the contract, but they are going to agree on a certain amount to settle their dispute. One of the prerequisites to have accord and satisfaction is that there has to actually be a dispute about the amount owed. If a contract is so definite that it sets the terms of what's owed, like an installment contract that has in there the exact amount of money that would be paid over the life of the loan, then we can't have accord and satisfaction because there can be no dispute about what's owed. It's spelled out to the penny in the actual contract. So there has to be what's known as unliquidated debts, meaning that what will happen in the event of a breach or what exactly is owed in terms of money is spelled out in the contract. If that's not spelled out in the contract and there's truly a dispute about what's owed, we have unliquidated debts, and we could terminate a contract based on accord and satisfaction. Otherwise, I say that I owe you $1,000 under our contract. You say that I owe you $2,000. We both agree we're going to split the difference and that we'll settle for $1,500. That is accord and satisfaction, and we've completed our obligations under the contract. A release is a valid discharge of contractual duties. So you'll see this a lot of times in insurance companies who are handling car accident cases. If they're going to pay out an amount to you to settle your claim, then they're going to require that you sign a release saying that that you're giving up any future rights to sue for anything else coming out of this accident. Those are valid. Sometimes you'll see in a contract, but not really often, a covenant not to sue somebody. There would have to be consideration given for that. In other words, in exchange for me to agree not to sue you if something goes wrong, you're going to have to pay me something on the front end to make it worth my while to agree to that. So as you can imagine, those are usually, they're pretty uncommon. Promissory Estoppel. This is an idea, and this is similar to the idea in quasi-contract, where there was not a contract, but the court was going to treat the parties as if there was a contract. Promissory Estoppel is a situation where there's not consideration, there's not valid consideration in the deal, and so we can't find that there's an enforceable contract because it lacks that important element of consideration. But the court is going to use the idea of promissory estoppel to supply the consideration. So they're going to treat the parties as if consideration has been supplied. Now, under what circumstances would we want to do that? So similar to quasi-contract, it's going to be in cases where somebody has relied on a promise to their detriment. They were reasonable in relying on that representation. They acted on the person's promise, and it would just result in an unjust resolution if we didn't find that there was sufficient consideration. So an example of that is that there's a mortgage on my house, and I'm behind in the payment of my mortgage, and the mortgage company says, we will promise not to foreclose on your house for the next 6 months, no matter what happens. And so the element of consideration is missing because I haven't really given them anything of value. I'm already required under the terms of the mortgage contract to pay them. So consideration is lacking. But if based on their promise not to foreclose on me for the next 6 months, I go and make all these expensive renovations to my house in anticipation that I am going to be, before the 6 months is up, able to catch up my mortgage payments and become current, then the mortgage company can't come in 3 months later and say, well, we're foreclosing anyway. You know, we didn't really have a contract because you didn't give us any consideration. And while that may be true, if we go to court, the court may say, well, we're going to use the doctrine of promissory estoppel to substitute for consideration in this example because you made that promise to Mr. Tebow. He relied on that promise. It was reasonable for him to rely on that promise, and he relied on it to his detriment by going and investing all this other money in improvements to his house while he was waiting out the 6-month period to become current on his mortgage. If I didn't do anything to my detriment, then a court is not going to impose promissory estoppel. So if the mortgage company says, we're not going to foreclose on your house until 6 months, and I don't do anything that would be considered acting to my detriment, I don't spend any money, I don't do anything, and the mortgage company comes back and says, we are going to foreclose in 3 months, and I take them to court, then the court is not going to find any promissory estoppel to substitute as consideration because I have not relied on their promise to my detriment. Another example of that would be if I worked for a company and they told me that when I retired, they were going to pay me a pension of $200 a month until I died, and I retire, and instead of going to get another job, I start collecting my pension, and 10 years down the road, the company says, we're not going to pay you that pension anymore because we didn't have a contract, you didn't give us any consideration for that, and then I would, if I took them to court, would be able to say, well, I relied on that promise to my detriment because I didn't get any other jobs during the 10 years I've been retired, and now I'm too old, or I didn't do any savings of my own, didn't create a 401k because the company promised me that they were going to make these pension payments. So in that case, the court might say we're going to use promissory estoppel to substitute as consideration, and we will find that there was, in fact, a binding contract. So that concludes Chapter 8. In Chapter 9, we're going to look at the remaining 2 elements of a valid contract, which are capacity and legality. And then just looking ahead shortly to next week, then we're going to talk about the sale of goods, lease contracts, and some of the other contracts that are more specific to business, and then how we recover if those contracts have been breached or not performed. So that concludes Chapter 8, and we'll see you next time.